Hi, I'm RG Skadberg, attorney with CCSK Law. So in your heart of hearts, you know you need to do something as it pertains to planning, but what that something is very confusing. The law does a great job of making the confusing even more confusing. And one of the things that we do in our little corner of the world that would be called estate planning, that we refer to as life planning, is use the term will twice. And unfortunately, they have nothing to do with each other. But people will just use the generic term will, but we don't know what that means, right? So there's two uses of the term will. This one we're going to talk about is a living will. The counter is a last will. We'll talk about that in another video. The living will, not only is it using the term will, which I don't like, it's also a horribly named document because it has nothing to do with living. It has to do with end of life. So this is the document. If you go into the hospital for anything, quite literally, I went in for a twisted ankle, I was in ER, and they asked if I had a medical directive. I said, what are you not telling me? This is the document that if something catastrophic happened, this gives the doctor's direction to say that you do not want to be artificially prolonged in your life, mechanically. So that the actual triggering questions at the top of the Indiana Living Will state that you have your attending physician certifies that you have an incurable injury, disease, or illness, that your death will occur in a short time. No one knows what short means. And the third thing and most important thing is the use of life-prolonging procedures serve to only artificially prolong the dying process. The living will says that you do not want to be prolonged artificially. The counter to the living will, if you were to read statute, and who doesn't do that on a regular basis, is a life-prolonging declaration. And the answer to the question of those three, if you're being artificially prolonged, the life-prolonging says, yeah, I don't care what you think, do everything anyway. In the thousands of living wills that I've done, I think I've done 3 life-prolonging declarations. It is not what people want. You need to understand, if you're in a hospital environment, a hospital's duty is to treat. So they have to lean into treating you, even if it is not going to be doing anything except artificially prolonging the dying process. So as I said, the vast majority of people do want to put a living will in place. The reason I do it is to address planning when things are calm, because when we get to that situation, it doesn't matter if you're going in for a non-emergency procedure. If you're sitting in the admissions chair there at a hospital, nerves are raised and they start asking you questions. They're going to ask you for 3 things. An insurance card, I can't do anything with that. They're going to ask you if you have an appointed healthcare rep. We're going to take care of that as part of our essential document package. And the third thing they'll ask is if you have a medical directive or an advance directive. And the answer to that question is a living will. So you're going to need it right at the beginning, even though you may never need it from an actual execution standpoint. Living will is medical. Last will, we'll talk about in another video. That's a different device. Not interchangeable, but again, an important document to put in place, because if you go to the hospital, they're going to ask if you have one. Be happy to help you. I don't charge for an initial consultation. If you just want to have some questions answered to understand what your options might be, give us a call, 219-230-3600, and you can also visit our website, ccsklaw.com.